Well, I'm going to call this group to order. There may be people, no doubt, who are just finishing classes and will wander in. That's fine, but we know you're on a schedule and want to move us on. I am Father John Jenkins, the president, and I warmly welcome all of you to this event. It's great to have you here, and it's great to see that so many people would take time out of a busy day to attend this event. The whole issue of conscience clause is an important dimension in the effort to protect and to hold up the sanctity of life. It's also a complicated issue, as I'm sure you know. It's issues of morality, issue of theology, of law, of public policy. And so it's particularly appropriate that here at this university we have serious discussions about it. And I believe that this is perhaps one of the special and maybe even unique contributions Notre Dame can make. With the expertise of our faculty gathered here, with people like Father Place from the outside to come and help us, it is an area in which we can make a special contribution, an important contribution to the public debate. And so that is why I'm particularly pleased to welcome you here, and I want to thank especially those who have worked so very hard to organize this event. And I'm thinking mainly of Peg Brinig, who's on a task force for life and kind of, I think, initially conceived this idea and worked so hard to implement it. Father Place, who's come with us, Carter, who's here. I just want to thank all of them and all who have worked to bring this about. I'm going to conclude here because there are people who have more substantive things to say than I do, but again, thank you for being here and thank all of you for participating. I think Rick Garnett's going to come up and say a few words to kick us off. Thank you very much.
Well, thank you, Father Jenkins. It's a real honor to have you here at the law school. On behalf of Dean Newton, who's on the road and so can't join us today, I just wanted to welcome everybody here to our beautiful new building and to this very timely and important and I hope thought-provoking event. I think it's especially fitting that this discussion is taking place in our law school, not only because this institution has a long and valuable and admirable tradition of advocating for the equal dignity of every human person, including the unborn. But if you think about what the legal enterprise is and what it is we're trying to do and what so many of you are learning how to do, part of that enterprise is pursuing a very difficult goal, and that's the goal of achieving justice in and through law. That's what we're trying to do here through this conversation. We have in our country today what many of us regard as an unjust legal regime, at least with respect to this particular question of not providing unborn children with full legal protection. That's something that many of us view as extremely regrettable and something to be struggled against. There's another level to the problem, though, and I think Father Jenkins alluded to this. It's a challenging problem, in that in a pluralistic society like ours, in one where not everybody agrees on even the most important questions, there have to be ways found to accommodate those. And in a free society, there should be ways found to accommodate those people who have moral and religious objections to what they regard as immoral government policies. But of course, not everybody can always be accommodated with all of their objections. Hence, the balancing challenge that we so often face, whether it's in freedom of religion law or in other areas. So I think our panelists today are going to help us to think through those challenges. And so I would just like to turn over the session to my colleague Peg Brinig, who's been helping to lead the way in the President's Task Force for supporting the Choice for Life and who really helped to convene this discussion, and she'll kick us off. But thank you for being here.
Welcome again. Thanks very much to President Jenkins for coming and gracing us with his presence, and to Francis Shavers from his office who provided the lunch, and to Dean Nell Newton, who's currently on the road visiting alumni groups in Phoenix, who is allowing us to use this facility for Rick Garnett, who's standing in for her and may help us out if we get into First Amendment questions later on, to the Center for Ethics and Culture, which sponsored a wonderful panel discussion on conscience clauses several weeks ago, and special thanks to my colleagues on the law faculty who've been very supportive and helpful all the way along, and on the task force. They're all here, and I'm delighted to see them. I'm Margaret Brinig. I'm the Fritz Duda professor, family professor of law. I'm the Associate Dean for Faculty Research, and I'm co-chair of President Jenkins' Task Force for Supporting the Choice for Life. I've taught family law and related courses since 1976, and have written extensively, among other things, on matters related to fertility, pregnancy, adoption, and families in financial distress. My current empirical projects, I'm an economist as well as a lawyer, include a large exploration of the effect on neighborhoods of the closing of Catholic schools in Chicago, one part of which is to be published in the spring in the Notre Dame Law Review, and his work with Professor Nicole Garnett, and one on the relationship between religion, race, family form, financial distress, and mothering. Some of these findings appear in my book, forthcoming from the University of Chicago Press next spring, called Law, Family, and Community, Supporting the Covenant. It's my pleasure to briefly introduce the other two members of our panel today. More fulsome information about all of us appears in the materials available to you on the conference website, which has a link today, at least, to the main university website, including a recording of this talk, which will be available tomorrow, and some text of possible conscience clause provisions. And that's at http://law.nd.edu about conferences conscience clause. Father Michael Place, for many years, was president and CEO of the Catholic Health Association of the United States, the national leadership organization of the Catholic health ministry in this country. Following that stint, he took up the job of being Senior Vice President for Social Mission and Ministerial Development for Resurrection Healthcare in Chicago, a task that involved representing Resurrection in matters of advocacy and public policy at the local, state, county, and federal levels. He currently serves as chair of the International Federation of Catholic Healthcare Institutions, which is associated with the Vatican's Pontifical Council for Healthcare Ministry. He has tremendous practical experience in dealing with the issues we'll address today, and importantly, in addition, he's a theologian who holds a doctorate in sacred theology from Catholic University of America. Carter Snead, well known and much beloved by those of you from the law school, has recently been appointed by UNESCO as a delegate to the International Bioethics Committee. Prior to this, he was general counsel to the President's Council on Bioethics, led the U.S. delegation, and served as its chief negotiator at the United Nations Culture, Science, and Education Organization for the Universal Declaration on Bioethics and Human Rights. He has testified in the House of Representatives on regulatory questions concerning RU 486. He writes prolifically about law and bioethics issues. To begin the task at hand, the development of a wise conscience clause from a Catholic university's perspective, I'm going to take an unusual approach, one that's apparently quite far away from the legal, theological, and ethical issues that Father Place and Professor Snead will untangle for us. I begin with the idea that discussions of abortion and issues related to it are far too often confined to a high and theoretical level. We wouldn't have to discuss them at all or take a stance as a Catholic university if every woman faced with the difficult choice chose to carry her baby to term. So I want to zoom in on her for a moment. As I told Father Jenkins during our very first discussion about the task force last August, the common denominator in difficult pregnancies is that the women, and sometimes the men, involved believe they lack support from the boyfriend or of the husband, from their parents, from their friends, from employers, and sometimes from us as a university community. Part of our job as we meet today, as we draft, and as we think about beginning of life issues after we leave here, is to make sure we're giving these families in crisis our full support. I quote only somewhat ironically from the Supreme Court opinion in Roe v. Wade. The pregnant woman cannot be isolated in her pregnancy and her privacy. While the court was talking about interests in preserving the woman's health and eventually the life of what it called her potentially viable fetus, my position is that by not providing her with life-affirming support, by isolating her in her privacy, we are far too often dramatically increasing the odds of her making the choice for abortion, even though the pro-life movement has and continues to make her aware of just what she's killing. A Gallup poll taken May 12th and 13th of this year indicated that for the first time, more than half of the Americans polled considered themselves pro-life, with about 60% classifying themselves as never favoring abortion or favoring it only in a few circumstances. Women's right to choose to terminate non-viable pregnancies was in some ways Pandora's box. If abortions were legal and as a consequence relatively inexpensive and safe, why should anyone else, particularly the baby's father and her parents, have to fund and validate what was her, read selfish, decision? Why doesn't it make sense to say that fathers, married or not, shouldn't have to pay for more than the cost of the abortion? Why shouldn't parents be able to choose for their pregnant minor daughters that they should abort rather than bear the embarrassing and expensive unplanned child? Why shouldn't employers and educational institutions provide for time? Why should they provide for time off, flex time, child care, baby changing stations, or family supportive housing? From a purely cost-benefit viewpoint, everyone who would be logically providing support for the choice for life of that unborn child has incentives that run in the other direction. As having a child became what some advocates in the childless by choice movement, and I've had them as former colleagues, feel is a consumption item, motherhood became a matter of volunteering. The pro-life choice, and especially the placement of the baby for adoption, became stupid and self-indulgent, in addition to being honestly downright hard. The empirical results are predictable. A Nobel laureate in economics, writing with his wife and another colleague, has documented the way that giving women the choice of reliable contraceptives and particularly elective abortion increased the number of pregnancies outside marriage and particularly hurt the bargaining position of single women who wouldn't have been interested in sex outside of at least a promise of marriage in case of pregnancy, who are precisely the same women who wouldn't be inclined to terminate any pregnancies. Still more recently, other empirical scholars have published results indicating that allowing abortion reduces in the second generation the number of poor women likely to have unplanned pregnancies, as well as the number of impoverished men of single mothers who are the most likely to commit crimes. With support for maintaining pregnancies, despite the fact that most Americans, including for the first time this millennium, a plurality of women, consider them pro-life, abortion will remain the choice of many vulnerable women. So far, and certainly other than starting us down the path in the first place through Roe versus Wade, the law hasn't followed this line of reasoning. It's so far, as Carter will tell us, permissible to publicly fund the medical expenses of pregnancy without funding abortions. So far, a parent cannot legally compel her minor daughter to abort, even though in some states she might have to bear some of the costs of supporting her grandchild. So far, a divorcing husband isn't relieved legally from supporting the child with whom his wife is pregnant just because it's her choice and he's willing to pay for an abortion. But these encouraging realities don't mean that a state may not cap public assistance at a level where an additional child results in no additional funding. The Supreme Court has said it may. It doesn't mean that a parent cannot tell a late teenage pregnant daughter she's no longer welcome to live at home, or that the funding's now gone for college. These things happen every day, and even affect college women no longer minors. The father of the child in question has many incentives not to be a supportive parent. He can urge and offer to fund abortion, and it certainly financially costs less than support for 18 years. Those who are not prepared to parent may not want the idea of having to put someone else's interests first all the time, or want to think about a genetic child over whom he has no control wandering out in the world. He may frankly be tired of the pregnant woman and not want her figuring in his life any longer. Similarly, and in the extreme case, especially where he's abusive, the pregnant women may not want to deal with him. While the law, at least in terms of spending legislation, may help to continue insurance and public support for funding prenatal and childbirth-related medical care, and while cases succeeding Roe v. Wade have made it clear that the legal choice remains the woman's, and fortunately in the direction of bearing the child to term, not her husband's or parents', what we might call preventative conscience clause issues, those involving not leaving the pregnant woman isolated in her privacy, those involving supporting her in her life-affirming choice, also need to be our concern. In my experience, as well as in the Gallup numbers, many, if not most women, realize that what they're doing if they have an abortion is wrong. In other words, many, if not most, have already internalized the fact of human life beginning at conception that the pro-life movement has been articulating so well since Roe v. Wade and is witnessed to so eloquently by the March for Life. Nonetheless, too often they reluctantly accede to what the Church teaches and what I, and probably the vast majority of you, believe is the wrong, though the practical, course of action. For the law students, this is sort of like the semen in Regina versus Dudley and Stevens. My point is that a woman's conscience with regard to the abortion question should be protected not only by providing her with adequate information and counseling and by legal protection against abortion by force, but also by her consciousness that others love her and her child and support her materially and morally right now and over the long haul in making a pro-life choice. The consciousness of sources of support means for her that bearing her child is really, practically speaking, possible, in addition to its being right. If doing the right thing seems impossible to her, she will accept abortion as the necessary evil of Regina versus Dudley and Stevens without really choosing it in the sense of wanting it. How's the woman's conscience to be protected? Some of the other projects the task force on which I serve is discussing with Father Jenkins, and indeed his original letter charging our task force, are designed to educate the university community about the need for such support through prayer, service, and sometimes financial help of women in crisis pregnancies and early parenthood. We ask that you stay tuned, not just today, but in the weeks to come, as we continue to make plans with a number of different groups on campus and off who have offered to partner with us in these activities. Now let's move on to what people, including those involved with the national health care legislation, generally think about when someone mentions conscience clauses. Once the pregnant woman decides to terminate her pregnancy, many other people are involved, and this is what the Supreme Court meant by not isolating her in her privacy. We turn first to Father Place to discuss the theological background behind conscience clauses and what Catholic physicians, hospitals, and other healthcare workers might want in a conscience clause. Professor Place will also update us on the current state of the healthcare legislation that has sparked so much talk about conscience clauses and abortion funding. Then we move to Carter Snead, who will discuss both clauses that protect against public funding of abortions and those that protect against requiring the use of human embryonic stem cells of infants. Finally, we hope to hear from you and to spend some time working on what can be a collaborative university project. Father Place.
Thank you very much, Peg. President Jenkins. It's a privilege to be with all of you today. My remarks are going to be in 4 sections, and In many ways, this is not a scholarly presentation. It's almost closer, for there's a few people left in the room who are old enough to remember catechisms, sort of a question and an answer. I'm going to be looking at 4 questions and giving bullet answers. And so the first question is, what is the Catholic view of the moral order? That could be, you should be scared to death that I'm posing that question, because we could be here 6 months and still not have even begun to answer it. But pertinent to this topic, we'll look at a few issues. Second, how do we view the relationship or the role of religion in society? And then third, what is our understanding of life, human life? And then fourth, in light of those first 3 perspectives, how does that impact on us and our understanding of being in the world post Roe v. Wade? So those are the 4 buckets. Catholic view of the moral order. According to the Catholic moral vision, there is an objective moral order. In other words, there is an oughtness to the human condition that is present not by human creation, but by the very meaning of what it is to be a human person. I would suggest that that perspective is shared by the foundational documents of our country and by the UN Charter of Rights. There are certain inalienable rights. We didn't construct them, we are ordered around them. In that context, then, we would say that there are crimes against humanity, and we will hold people accountable for genocide. An objective moral order. In light of that, individuals and society have an affirmative obligation or responsibility to promote and protect this objective order. And doing that is essential to the well-being and advancement of the integrity of individuals, as well as to the integral development of human persons in society. Third, according to then, in our pursuing personal integrity and the integral development of society, there is an individual and collective responsibility to do good and avoid evil. An affirmative responsibility to do good and avoid evil. The good and the evil being identified in the context of this objective moral oughtness about being human. Unfortunately, the reality is that evil is in the world. Different faith traditions or different human philosophies will give explanations as to how that evil came into being, but the reality is there is evil in our midst. Badness is done. And we cannot avoid coming up against it. And so we then have to ask the question, in this objective moral order, this oughtness, this obligation to pursue the good and avoid the bad, the evil, what do we do in the face of the presence of evil in the world around us? The answer to that is we may never make our own the evil doing of another. We may never make our own the evil doing of another. There can be occasions, however, when we can be forced or circumstantially set next to another's doing of evil. And there the obligation is never to get so close that we become complicit in the evil of the other. Which is a fancy way of saying, never get so close that I myself become tainted by the other's evil doing. We would affirm that that obligation which is present to individuals is also the responsibility of social institutions, including the government. The right ordering of society is one, then, that ought to prohibit certain actions because they contravene human goodness. And that government itself, as a social agency, should not be complicit, should not become so close to evil that it itself is tainted. So that's part one. General view of moral order. Second part, religion and society. Any person who has been a student of church history knows that there has been an evolution, particularly since the Second Vatican Council, on the Church's perspective on the right ordering of society and the role of religion in society. So I'm speaking then to a post-Vatican II perspective on this question. According to that understanding, then, the right ordering of society in such, government ought to provide space for the free exercise of religion, as well as for the personal conscience of citizens. Space for religion, the exercise of religion, and the personal conscience of citizens. Within society, which is bigger than government, is an aspect of society. Society is larger than government. The social ordering of a space, society. Within society, religion has three potential roles. First, the forming of the conscience of individuals. In a sense, helping to form, and I believe it was Jefferson who spoke of it, a good citizen. Secondly, through its institutional works, if the religion has such, not all religions do, but if an institution is expressed, if a faith tradition is expressed not only through its worship and religious instruction, but through institutions of service, religion has the ability to function in the voluntary sector of society to advance social goods such as education, charity, health care. So religion can advance the well-being of society through its institutional works. A third role for religion in society is to bring its moral values into the public discourse about what will become the shared moral vision of a society. In a way, just as individuals have consciences, so too societies develop its own conscience, vision. And you bump up against it when people see something in contemporary space. You see something on society, something will show up on television or on YouTube, and people go, ooh, it's just, where does that come from? Well, it comes some from our own upbringing, but also a shared sense. We just don't do that. In something like a university or a business, cultures develop. When I was leading CHA, one of the things that used to drive me actually crazy in the first year, you'd ask about something, you'd say, well, that's not how we do it here. Now, where did that come from? Well, that's a shared vision. So one of the things religion contributes to is the development of that shared dialogue about how do we understand ourselves? A shared moral vision. In the United States, the Catholic Church has been actively engaged in all three of those realms. There are some, however, who are suggesting that the role of religion should be confined to the first realm of the conscience, the formation of a good citizen, and that to claim space in the other two sectors is inappropriate. Infringement on the rights of others, as distinguished from collaborating with others in those spaces. That in itself is a background discussion that oftentimes is the real discussion in play around conscience clauses. Where should religion be? How does religion exercise itself in this constitutional order? Going then to the third and a very short section on what is our understanding of human life. Roman Catholics affirm that all humans, and in my text this is italicized, by virtue of their shared human dignity, all humans by virtue of their shared human dignity have an obligation to promote and protect life, and consequently are precluded from the direct taking of innocent human life. So it's the obligation, affirmative obligation to protect, the prescriptive obligation not to directly take innocent human life. From the Catholic perspective, and this goes back to part one, this comes by virtue of the shared human dignity. It is something held in common in a sense that is there before a religious warrant. And therefore, it is not a religious obligation first, but a human obligation. Secondly, this right to life is so essential to the well-being of individuals and society that it is the responsibility of government as well to protect that right. Not all rights require protection by government in first order. Those, however, that are foundational to the very fiber of society, government has a different responsibility, and our perspective is the right to life. Without life, there is no society. So it is a fundamental responsibility. So we have no problem making laws about homicide. There's a myriad of laws dealing with protecting human life. Then from our perspective, abortion, that is the direct taking of innocent life of the unborn, violates the shared human obligation to preserve and protect human life and dignity. And the ergo, then, is that individuals, social institutions, and government policy, therefore, should not engage in or be complicit with abortion by virtue of our shared human dignity. Okay, those are the first three parts. Now, if you hold those three things, obviously Roe v. Wade is a problem. Because what it does is it unsettles that compact of shared responsibilities with regards to innocent human life. Now, I'm going to get myself in potential trouble here because I'm going to, as a moral theologian and a public policy dabbler, talk about what I think the legal terms of Roe v. Wade are, and then tie that into the conscience discussion. And oftentimes, at least in my discussions with people in Congress and elsewhere, this next point is one that easily is glossed over because it's convenient to ignore what actually Roe v. Wade did. As wrong as it was, as Peg said, it didn't do everything. So, what did the court do? It found that the privacy right, the right to privacy, was broad enough to include a woman's decision to terminate a pregnancy. That privacy right within which is the decision, however, is not unqualified and must, according to the court, be considered in the context of other state interests, such as protecting health and potential life. A qualified. So since Roe v. Wade, the Supreme Court and other courts have been engaged in the discussion about how to balance that qualified right and other state interests. If it weren't qualified, we wouldn't be discussing parental consent, parental notification, waiting periods. All those are present because it's qualified. Another critically important distinction that has come out in the jurisprudence associated subsequent to Roe v. Wade is that there is a fundamental difference between a state being limited in its engagement with a protected activity, and the state encouraging that activity. According to the courts, government is not required to encourage or support abortion. That doesn't mean it can't, but it's not obligated to. And so we have discussions about whether there is federal or state funding, etc. Those are public policy discussions, not right discussions. In addition to those two debates, namely the balance between a qualified right and state interests and the question of whether public policy should encourage abortion, there has, in subsequent to Roe v. Wade, arose the question of how much freedom is to be accorded religious persons and religious institutions and other persons and institutions whose moral vision, deeply held moral belief, understands the meaning as the perspective that the meaning of our shared human dignity disagrees with Roe v. Wade. This is a religious question, and I'm going to primarily focus on that. But it's also a question for folks who have a moral conviction and do not have a religious belief or warrant for that. While there is not a constitutional requirement that the government give space for this disagreement, it can be argued that the right ordering of a pluralistic society in which there is such a fundamental disagreement ought to provide space and should not require that individuals or institutions engage in activities that violate something essential to their worldview. In fact, to date, that argument has prevailed. At the state and federal levels, there exist conscience clause protections. First, for individual providers, nurses, physicians. With the move to more chemical means of abortion, there is less consistency and, in fact, a huge debate over protection for pharmacists, since the drug can now be provided pharmaceutically. But for nurses and physicians, there is space. There also is, through the Church Amendment, space for hospitals, religious and others, whose moral conscience says they choose not to do abortions or sterilizations. Let's talk about institutions. So there's protection for individual practitioners, not consistent or even, but protection. In the United States, the Catholic health care is the largest single provider it's the largest provider under one sponsorship of health care in the not-for-profit sector. 16% of admissions to non-government acute care hospitals in the United States are to Catholic health care institutions. There's 630 plus Catholic hospitals. They are present oftentimes where others are not. Huge presence in rural America, significant presence in poor communities in the cities of the United States. Because how does such hospitals get engaged in the question of providing abortion? Why would it even be a problem? Because they participate in Medicare and Medicaid, which are federal programs. And they have regulations or rules for participation. Like you can't be in the Medicare program unless you have an emergency room. So the government can establish criteria for being part of the program. So if you weren't part of that, a poor person in Medicaid would come in and you couldn't charge the government. Someone over 65 comes in, you couldn't charge the government. So in effect, about half of your patient base to 60% of your patient base would not be available to you, which in effect would mean you're not able to serve the community. In that program, there is the Hyde Amendment, which provides that there will be no federal funding for abortion other than in the case of rape, incest, and threat to the life of the mother. So in the United States right now, by virtue of the Church Amendment and the Hyde Amendment, there is Conscience Clause protection for individuals and institutions. Excuse me, yeah. That Hyde Amendment, you can look at it from two sides. One is the conscience of the individual, of the hospital, and the other is the role of government. So in effect, the Hyde Amendment does two things. It protects institutions, but almost as importantly, it says government will not be engaged in funding abortions. So it deals with that third level of how do we understand the ordering of society. It is that is at debate with the current health care reform. The position of the bishops of the United States has been totally supportive of health care reform. We believe health care, the right to access to that health care is a fundamental social good. The right of access to health care is a basic human right. And we need to reform the system to ensure that to happen. But what the bishops have said, that reform should not in any way change the status quo with regard to protection of individual conscience, of providers, institutional conscience, or the role of federal funding vis-a-vis abortion. And so the Stupak Amendment in the House bill became the vehicle, and it's very complicated, and don't ask me at any time to get into all the details of it, because in many ways, in the last minute, what the language of protection is going to be dependent on what the bill does. So if it doesn't create insurance exchanges, then you're not going to worry about precluding certain forms of participation. So it's the specifics of the bill. So the question is, when you figure out what is the vehicle, the legislative vehicle that's going to advance reform, how do you make sure that we have not narrowed the protections that are currently there in any of those three dimensions? That's the debate on the floor. Not expanding acts, not narrowing the rights of individuals, not expanding the presence of government funding to abortion. In closing, then, one thing before closing, I want to talk about language. You know, we lost. One of the ways you can lose discussions in the public space is you forget, you don't carefully watch how words are changed. One of my big things is that we used to talk about patients in healthcare. Now the language is about consumers. It's a whole different relationship between a patient and a provider and a patient, and a seller and a purchaser. I think healthcare is so essential to the human dignity of individuals and the vulnerability that it's not a consumer. It's not a Best Buy relationship. Well, abortion proponents changed vocabulary. Instead of saying we want to be about the ability to take life, we were here to affirm the choice of individuals. Changes the whole terms and frames of the conversation. In the last several years, and this has been very clear in the debates about the amendments, folks are saying in health care reform, if abortions aren't paid for, then you're interfering with a woman's right to health care. So they're taking abortion and saying that is now a health activity. Well, how can you be so you're put in a conundrum. We say everyone has a right to health care. Abortion's health, so how can you preclude federal funding for health? So we are now in having to shift, the conversation shifts, and we've got to come back, and it looks like we're trying to impose our religious views on someone's right to health, rather than a discussion about what is the fundamental meaning of human life and the role of society in protecting life. In conclusion, then, what are the questions behind the questions? As I said before, what is the role of religion in society? Is it confined to the personal order, or does it have a public role? And if so, what is that role? Secondly, is society and government accountable to a higher order of a shared understanding of human dignity? Or is law just a positivistic experience that comes and goes based on momentary needs? And third, in general, what is the role of government when there exists in society a profound disagreement about what should constitute a shared understanding of human dignity? And fourth, more specifically, what criteria should inform government exercising its ability to provide space or liberty for religious or deeply held moral convictions that differ from current law or policy? Those are the kind of robust discussions we need to have, not try and solve it all in individual amendments. So in conclusion, in light of all this complexity, the work that is going on at this fine university to try and craft a coherent approach to conscience clause, one that both honors the tradition of our church and of its teachings, but also the complexity of our constitutional experience, is incredibly valuable and important. The making of government is a dirty process, a messy process. And oftentimes it is the end product is compromises that bring together antitheses that in fact cannot live together, and it's just the consequences of bad laws are horrible. One of the great gifts the Catholic Church has to this country is that we have a coherent moral vision. that can provide a coherent reference point for discussion. That doesn't mean our vision will be accepted, but its coherency allows for a more focused debate and discussion. And so what all of you here are doing is a great gift to the nation to help provide a coherent basis for a much-needed public policy discussion. Thank you.
Thank you very much. Thank you to my colleagues, Father Jenkins, to the task force, and for all of you. I'd like to associate myself with everything that has been said so far. I think it's an eloquent testament to the propositions that we're defending, and also to this forum more generally that we were able to listen to those very insightful comments. I'd like to, before I turn to my charge here, to amplify, underscore, and recapitulate a little bit what was said before, not because it wasn't said well, because it certainly was beautifully, but it just bears reminding ourselves and to draw our attention back to a few fundamental things before I turn to the question of federal funding and what the obligations of citizenship and the role of the government in the context of the funding of abortion and the funding of embryo-destructive research entails. I'd like to underscore Father Place's and Peg's as well comments about our perspective. We're coming from a unique perspective here, namely the Catholic Church's perspective. It's a very thick and coherent moral anthropology. It's a thick and coherent conception of the common good, and also whose good counts within the common good. And also it has a very thick and powerful account of what human beings are and what constitutes human flourishing. And I think that makes our discussion rich and useful for the nation at large, not just for this room. But it's important to underscore also that the propositions that we affirm, the Catholic Church's propositions regarding the dignity of human life and the injustice of taking innocent human life, are not received dogma. They're not based on revelation. They are, as Father Place said, human claims that are rationally articulable and rationally sort of digestible, understandable. Now, not everyone will be persuaded by our arguments, but our arguments are grounded in axioms and in propositions that everyone can understand, people of the Catholic faith, of course, people of other faith, people of no faith. The arguments that we're making about the inviolability of nascent human life are grounded in essentially two premises. One is one that should be very familiar to you as Americans, that every human being is created equal, and that everyone possesses intrinsically and pre-politically an equal dignity that doesn't depend on the judgment of others, that doesn't depend on our usefulness to others, that doesn't depend on the strong's needs, defining the circle of humanity according to their needs and giving to the weak what they are entitled to, what they want, depending on those needs. So that's something that's really important, but it's also something that's not unique to the Catholic faith. It's something that we should understand. It's a principle that undergirds our laws in the United States. And we believe, by extension, along with our foundational documents and the laws that flow from them, that the government has a responsibility to protect innocent human life, that the government has a responsibility to ensure the equal dignity of every human life. The second premise on which our arguments rest is a simple biological observation, namely that human beings, from the moment of conception, are biologically human organisms, therefore human beings, members of the human family. And so we have a capacious understanding of who are rights-bearing individuals. But again, it's not a received dogma. It's not something that you have to subscribe to our faith tradition to accept or even understand. It's a simple proposition that's confirmed by modern embryology, that human beings at the moment of conception are human organisms. They're living members of the human species. And as such, we believe that they are entitled to the our equal moral regard and the equal protection of the law. What flows from this is that we need to be also clear about what's at stake and what conscience means in this context. It means something, I think, more capacious and broader than what most people mean when they use the word conscience, about just a claim of wanting to be individually exempt from a practice that may otherwise be acceptable because of some peculiar view that they happen to have, either because of their religion or because of some moral scruple that they have. the claim of conscience here is something different. The claim of conscience here is a plea not to be conscripted into the participation in injustice. And when I'm especially in the context of federal funding of abortion and the federal funding of embryo-destructive research, it's a claim to be not to be coerced, which is embedded in a much larger plea that were raised by both of the speakers about the injustice of abortion, about the injustice of embryo-destructive research. So it's a larger kind of a claim. It's not, and also it admits then of a larger discussion, a more wide-ranging discussion that brings in concepts that Peg was talking about our obligations to a pregnant woman in a crisis pregnancy that Father Place was talking about as well in the context of institutions and individual healthcare providers. So I think that with that in mind, I think I'm going to go ahead and proceed to my remarks about the unique context of federal funding and the obligations of citizenship and the rights of citizens as well. And by the way, I'm not talking about constitutional claims. I'm not talking about Establishment Clause of the First Amendment. I'm not talking about the Free Exercise Clause of the First Amendment. I'm talking about the obligation that government has in justice to make space for people to exempt themselves from these practices, and the obligation and justice that the government has not to coerce individuals, institutions, or public resources into the commission of injustice, and also to act in the good of integrity and integration. That is, to promote the good of integrity for individuals such that they can live and act in accordance with their most deeply held moral beliefs. So we're talking about what the government should do as a moral matter, as a matter of justice, not about what the First Amendment requires the government to do or doesn't require the government to do. We can certainly talk about that during the question period. But I'm making a broader and I think more important claim than that particular constitutional question. So let's talk about federal funding then. Federal funding is an abstract matter. It's important to understand its significance both in a concrete and sort of practical way and in a deeper, sort of more theoretical way. Concretely, the issuance of federal funding for a particular activity is assured to increase its incidence. It is the manner in which the government funds favored activities, creates incentives for people to engage in those activities. And even though it's a little bit of an oversimplification, it's nevertheless true that if you want more of something, you fund it. If you want less of something, you tax it. If you want none of something, then you criminalize it. Right? So it's important to understand the concrete implications of a government's decision to fund a particular activity. But it's also useful to situate federal funding in a richer sort of way in the spectrum of government regulation and its pedagogical significance. Government is, as Justice Brandeis said, the omnipresent teacher. It not only mediates relationships and prescribes certain activity and limits others and encourages certain activities, it also teaches. It both reflects the norms of our polity, but it also, in some ways, helps us constitute those norms themselves. It informs people. It not only reflects our values, it sort of has a constitutive role in the creation of our values as well. And so that's important to keep in mind, and federal funding plays an important role in that process. The government, all laws, and this is important for Notre Dame law students, it's something I say every semester, and it's important for everyone to understand that all laws are deeply morally laden. All laws aim at a particular good to be defended or aim at a particular harm or evil to be avoided. And the government has a multifaceted array of tools at its disposal to do that. From the most restrictive end of the spectrum, the government has the power to criminalize certain behavior. And that sends an obvious pedagogical message. That's symbolically important in that it says this is not to be done. The government condemns this behavior. Moving in sort of from that end of the spectrum to the more permissive end of the spectrum, the government can give permission to engage in certain kinds of activity with strict conditions, or to, as a default rule, forbid something but make certain kinds of exceptions, which illustrates, again, a deep sort of caution on the government's part about the worthiness of the activity in question. The government can permit certain activities, but with surveillance not impose restrictions exactly, but rather require data collection, which signals to the polity that attention must be paid to this. This is important. We're going to allow this to go forward, but we have certain concerns that we're going to take note of going forward. Moving further to the more permissive end of the spectrum, we have silent permission. Silence in our system denotes permission. It's a silent sort of neutrality. It's a neutral tolerance of a particular course of activity. Moving further still, we have positive encouragement and inducement. We have the situation where the government says, this activity is worthy. We want to put our limited resources behind this activity. We want to encourage this activity. We think there is a good at stake here that we need to provide. And that's what federal funding represents. When the government makes a decision to fund something, it is speaking in a very important way. And not only is it speaking in an important way about its values and what it considers to be a worthy activity, it also is conscripting taxpayers into supporting that particular judgment as well. And there's a certain measure of coercion that's brought to bear in that circumstance that we have to take note of that's very relevant to our conversation today. So that is, in sort of an abstract way, situates federal funding and its symbolic and pedagogical meaning within the array of tools that the government has at its disposal to pursue goods and avoid harms. So what about the federal funding of abortion and the federal funding of embryo-destructive research? Well, as my colleague said, there is a long-standing policy in place since 1976, the Hyde Amendment, which was referred to by Father Place, which prevents the funding of abortion by federal dollars within the Medicare and Medicaid regimes, except in narrow circumstances, that is in the cases of rape, incest, or when the mother's life is threatened. And this is what's called an appropriations rider, meaning it's an amendment that has to be appended to every single appropriations bill that comes with each new Congress. So it has to be renewed every single year, and in the early years there was a bitter dispute about it, but appropriations riders tend to be boilerplate after a certain passage of time, and so the Hyde Amendment has been renewed every single year since 1976. Although that's not to say that it's not controversial. There are active campaigns on Capitol Hill to remove the Hyde Amendment altogether. But for now, the Hyde Amendment is in place, and it does forbid the use of federal funding in the Medicare and Medicaid programs to fund abortion. Now, Father Place mentioned recently, and again, this is sort of the healthcare discussion on the Hill right now is in process, so it's hard to say anything concrete about it. But recently, at least in some iterations of the bill, and the iteration of the bill that's being considered in the Senate right now, there is a proposal to depart from that long-standing neutrality. The failure to pay for abortions evinces a governmental neutrality towards the question of abortion. Okay, it's a neutrality. They're not endorsing it. They're not forbidding it. It's a posture of neutrality. And there is a proposal to depart from that posture of neutrality in some iterations, in some aspects of the health care bill, in which abortion would be funded either directly or indirectly by federal dollars. And that's a very, and our talk is timely today because that's a very serious departure from longstanding norms, longstanding federal policy. Similarly, there has been, at least until this past year, a longstanding history of neutrality on the part of the government towards embryo-destructive research. Human embryos were isolated through in vitro fertilization. They were conceived outside of the body for the first time by Steptoe and Edwards in England in 1969. The first birth from IVF, of course, was Louise Brown in 1978. But before that, they conceived human embryos outside the body. And this, of course, provoked, along with Roe v. Wade in 1973, a debate in the United States about what should be the federal government's role vis-a-vis embryo-destructive research. Embryonic stem cells were not yet on the scene until 1998. They were talking mostly about embryo-destructive research aimed at studying human development and perfecting IVF techniques. So there was much debate and discussion in the 1970s about this particular question. And the concrete result, there was written into law, ultimately in the 1970s, a requirement that any federal funding for embryo-destructive research be approved by a federal body called the Ethics Advisory Board. Now, Ethics Advisory Board issued a report arguing in favor of certain limited federal funding for embryo-destructive research, but before that was implemented, their charter expired and their members' tenure also expired. So there was an ethics advisory board in place, but there were no members. But the requirement of the law that the Ethics Advisory Board approve any federal funding of embryo-destructive research remained in place. So there was, in effect, a federal law that said a non-existent board has to approve any federal funding for embryo-destructive research, which resulted in a de facto moratorium on federal funding for embryo-destructive research throughout the 1980s and until the end of the first President Bush's term. President Clinton came into office in 1993, January of 93, and wanted to change the law. The Congress, at his behest, changed the law to remove the requirement for EAB approval, and he began to make preparation to federally fund embryo-destructive research. Congress changed hands in 1995. The new Republican majorities didn't have the same view of federal funding of embryo-destructive research that President Clinton did, and they immediately attached another appropriations rider. It's kind of interesting that most of the public bioethics in this area, most of the debate and dispute about the nation's position vis-a-vis embryo-destructive research, abortion, and so forth, have been about funding, have been about federal funding. And that was true in this context as well. So they attached an appropriations rider called the Dickey Amendment that said that no research shall be funded in which embryos are used or destroyed. Living human embryos are used or destroyed. So this was the law until 1998, during which time embryonic stem cells were isolated for the first time, pluripotent cells from human embryos, a great deal of excitement in the scientific community, in the patients' community, patients' rights community. President Clinton renewed his efforts to try to figure out a way to fund this kind of research that depended on and incentivized the use and destruction of living human beings at the embryonic stage of development. So his general counsel, law students take note, lawyers have a great deal of influence in this context, through a very creative and narrow construction of the Dickey Amendment, said, we can't technically fund research in which embryos are destroyed. That's the letter of the law in the Dickey Amendment. But we can fund research on embryonic stem cells that are derived from embryos that have been destroyed using private funds. So person A, sometimes this was actually the same person. Person A would destroy the embryo with private funds, kill the embryo, take the stem cells, and then hand it to person B, who would then receive federal funding to conduct stem cell research. So in this way, the law actually incentivized and promoted the use and destruction of human beings without funding it directly. That was the construction of Harriet Rabb, the general counsel of the Department of Health and Human Services. But before any funding could be authorized, President Bush was elected in 2000, suspended that protocol, and came up with his own policy in which he would only fund that species of pluripotent stem cell research that did not create future incentives for the use and destruction of embryos. And I can get into the details of that if you want to during the question period. But the bottom line is, until this year, there's been a stalemate between the political branches of government, and President Bush's policy was challenged by Congress, and he vetoed efforts to undo it twice. There's been a stalemate between the political branches of government such that no federal funding has ever flown, ever, to research that promotes the use and destruction of embryonic human life. That is until President Obama was elected, and with him a Democratic Congress who had a uniform view of what the federal government should and shouldn't fund in this regard. And as of yesterday, it was announced yesterday, additional reason why this is so timely, the first stem cell lines derived from living human embryos were funded by the Obama administration yesterday. So we've actually seen a radical departure from the government's position of neutrality for the past 30-plus years on the question of embryo-destructive research. Now, embryo-destructive research is being promoted by the funding of embryonic stem cell lines derived from living human embryos. So that's the sort of overview of the history of federal funding. So the question for us then, and the question for me in particular, is what do I think, given all of our premises about human dignity, human flourishing, the common good, the equal dignity of every human life from conception to natural death, what would be an ideal law governing the federal funding of abortion and embryonic stem cell research? And I think that, and my answer is fairly straightforward. I mean, this follows along Father Place's remarks as well. It's my position that public funding should not be used to provide or subsidize abortion services directly or indirectly. There are a lot of ways to subsidize and promote something. You can do it directly, that's obvious. There are other ways that you can promote it. The embryonic stem cell discussion that I just mentioned a moment ago is one illustration of how you can promote something without funding the actual destructive act itself. So it's my position that public funding should not be used to provide or subsidize or support abortion services directly or indirectly. And Father Place made the point that as part of the rhetoric that we're observing right now is that the proponents of public funding of abortion have used rhetoric that suggests that the Catholic Church and those who agree with it are opposing health care when they oppose to public funding of abortion, that it's unjust not to fund the intentional destruction of living human beings. And to that, I think Father Place's response is apt, namely, we don't regard the intentional killing of innocent human beings as health care. We don't regard that as part of what healthcare providers should be doing. And so we have to reclaim the richer understanding of what healthcare is as if we're going to be effective in this debate. And Father Place is exactly right about that. Similarly, I would say that there should be no federal funding of research, obviously, that depends on and promotes the use and destruction of human beings at the embryonic or fetal stage of development. And that would include funding research on embryonic stem cell lines even when you don't fund the embryo destructive act itself. I think President Bush's policy went too far. I don't think that he should have funded the embryonic stem cells that were derived before the announcement of his policy while foreclosing that going forward. I think that went too far. And why then would I take this position with respect to abortion and embryonic stem cell research? I think, as I said before, it's wrong for the government. It's wrong for the government as a matter of justice to coerce individuals or institutions into the support of a grave injustice. It does violence to the notion of personal integrity, which is a subsidiary point about the integrity of a person's conscience, that they're able to act the way they, in accordance with their moral beliefs, or they're forced to act in ways that are in tension with that. And I think federal funding in this context, especially of embryo destructive research, embeds in the law and expresses approval for the principle that some innocent human lives can be used and destroyed solely for the benefit of others. And that does great violence to the notion that all people are created equal. There can't be a contingent equality. It can't be the case. If we take equality seriously, it can't be the case. It's a self-destroying notion that equality is decided by the strong, who gets to decide who's treated equally and who's not. Equality has to be intrinsic, it has to be pre-political, and it can't depend on contingent things like the esteem of others, one's dependency, one's usefulness to others, one's fate. Am I going to die? Well, in that case, I have different... If I'm doomed to die in any event, then is my life worth less than someone who's got a full lifespan? And I think that even a governing regime, and this gets to Father Place's point about rhetoric also, that even a governing regime like the one that's in charge now that favors abortion rights and favors embryo destructive research should nevertheless refrain from funding it and imposing that in a coercive fashion, imposing that view on taxpayers. Because it's disruptive of integrity, it's disruptive of civil peace, and it really fails to pay adequate respect for pluralism. And this is true especially in the embryo destructive research context, when there are alternative approaches to stem cell research that are fruitful and interesting and could be pursued in the alternative. Finally, before I finish, I just want to say a brief word on Catholic universities generally and Notre Dame specifically. We have at Notre Dame and Catholic universities affirm a particularized, thick conception of the human person, human flourishing, and the common good. And we conduct our research, scholarship, teaching, service in a way that respects the matchless worth of every human life from conception to natural death. And the government needs to make space for this. And part of the conscience protections that I propose is that no university, especially universities with a religious mission, should be compelled as a condition of funding or as an advantage of obtaining grants, be required to perform, support, promote, collaborate in research involving the use and destruction of human beings at the embryonic or fetal stage of development. They shouldn't be compelled to train people to do abortions. And as to Notre Dame, and this came out recently in the context of our new adult stem cell initiative, I'm proud to say that Notre Dame does not engage in or support any research that involves, promotes, or implies approval for the intentional use and destruction of embryonic or fetal human beings. We have a policy in place that prohibits research on primary human tissue or derived cell lines obtained through elective abortion. And this way, I think Notre Dame not only does the right thing, but it also takes seriously its obligation as a premier Catholic research university to affirm and bear witness to, in a public way, the equal dignity of every human life. And I'm proud to be associated with this university for that reason. So, thank you very much.
Some of you I know are going to have to go to class at 2, but we do have this room reserved until then anyway. So if you want to ask questions, there's no way that the sound can be picked up for anybody who's going to be watching this broadcast tomorrow unless you speak through a mic. So I'm giving the mic to Professor Garnett here to pass around to those of you who want to ask questions.
Thank you. I have a question, and maybe this is most appropriate for Professor Steve. What do you do in the case of, say, the Department of State really wants to fund an agency that promotes development in West Africa or something like that, and it's a really fabulous agency, and it's in line with the kind of the ethical responsibilities of the United States as a powerful country. But this particular agency, as a practice, sometimes funds abortions. How do you weigh the good and the evil? And is it something that you never cross the boundary of ever indirectly funding abortion? And how do you deal with that conflict?
I'm going to stand up and answer your question. This is part of, and this may be an indirect way of answering your question, but I think what's crucial here is to keep in front of us. Now, we always want to other people. We always want to measure our rhetoric. We always want to preserve the possibility of dialogue with others who disagree with us, and we always want to be respectful of them just because they're our fellow human beings, and we have an obligation in charity to do that. At the same time, it's important for us to keep in front of us what it is we're talking about, okay? What it is that we're talking about. What we're talking about here is the intentional killing of innocent unborn children, okay? So one way and we have to keep that in front of us so we can avoid being confused by abstractions, right? So the question, if you rephrase the question in the following way, just as a thought experiment, there's an agency that I want to support. They're doing good work. They're helping people in many important respects. But they're also intentionally killing children. How does it sound? You know what I mean? Like, and again, I'm not trying to be provocative. I just think that we have to be vigilant in reminding ourselves what it is that we're talking about. We're talking about a gross and appalling injustice. Right? So if we affirm that position, if we affirm that abortion is the killing of an innocent human being, if we believe that, if we really believe that, then these questions, I think we have to remind ourselves of that belief when we ask ourselves these questions.
I had a question about pharmacists and conscience clauses as it relates to them. Can you give us a brief account of where those kinds of things stand?
Not as good as it ought to be. Not as good as it ought to be. It's very uneven. I know in Illinois it has gone back and forth, and it's caught in this consumer mentality that if I want to buy something, that I should get it, and there should be no. So it's this image that if a pharmacist is, and if you're in a small town, it all comes down to small town. It's not going to happen in Walmart, but if you're in a small town, there's one pharmacy owned by someone, and they don't believe in abortion, then I'm going to have to drive someplace to get the pill, the script filled. And that's the emotional rhetoric. So it turns on inconvenience versus personal integrity. And in a utilitarian society, personal convenience will trump at times. And the other piece of it in the political, God love pharmacists, where would we be without them? But they don't have a lot of money. So there's not a pharmacist lobby that is as powerful. So really the only collaborator for pharmacists who have a conscience issue is the Catholic Church. And since this is being taken on at the state level, our moral suasion at the state level because of the priest misconduct is about 1/10 of what it was 10 years ago. So we are not as effective.
My question involves, you often hear of a conscience clause, which kind of implies that there's a body of law to which the clause is applying. But it seems like in the presentation, the talk and the discussion was more on the underlying body of law and what it says. Are there instances where, is it more often where the clause is taking an exception to the body of law? And does that do some sort of disservice to the underlying teaching method of the law for the entire society if you have these exceptions that you pull out, and how does that interact with the teaching function?
Yeah, I think that, again, Father Place is important. It makes an important point in drawing our attention to rhetoric and framing. The issue, again, as I said in my remarks, I think that that conscience in this context means something, in the context of life, means something different than it means in other contexts. And I think Professor Garnett said that as well in his introduction. It is a bigger claim. It's one part of a much larger opposition to an unjust legal regime. Now, opponents of conscience protections refer to them as refusal clauses, right? Or they refer to them as, I want to opt out of something that's otherwise perfectly respectable and responsible for some kind of idiosyncratic reason. And my impression is, or my view is that that's a very prejudiced way of formulating the question. It really is, in this instance, in the context of the life issue, it really is a larger claim about not wanting to be conscripted into a grave injustice. And I want to make one other point about the body of conscience law that we have, at least at the federal level. And Father Place did an excellent job of summarizing for us the conscience protections. Peg mentioned them as well. One of the problems with the amalgamation of conscience laws that we have from the 1970s, and there is actually an appropriations rider called the Hyde-Weldon Amendment from 2004, I think it was, which sort of clarified some of the definitional issues. But even with that, there is a great deal of ambiguity, I think, and this is just my own personal construction of these laws, a great deal of ambiguity about sort of what's covered, about the definitional matters. And there's a terrible inadequacy on the part of the government in terms of publicizing what individual rights and responsibilities are vis-a-vis conscience, and their woeful enforcement mechanisms. So this is a kind of a technical legal point, but I think for a conscience clause to be effective, you have to disseminate it, you have to publicize it, you have to let all the relevant actors know what their rights and responsibilities are, and I think you have to have a meaningful enforcement mechanism. And this, by the way, was the reasoning behind the regulations that were announced at the end of of President Bush's administration in 2008, which are in the process of being nullified. I think that they did a good job, actually. This is just my own personal view. Did a good job of filling in gaps and providing meaningful enforcement mechanisms for the extant conscience mechanisms that were mentioned before. By the way, one other important point, and I think this is a moral obligation of people who are invoking the right to conscience, and we've talked about this a little bit, but I think there's an obligation on the part of physicians, pharmacists, institutions to be upfront with the public about what they're not willing to do, right? So there's no confusion, and obviously you want to bear witness to your moral views, and so that's a salutary effect of that. But also, you don't want to confuse patients, and you won't run into this problem of someone showing up at a hospital and saying, "I want an abortion." Well, wait a minute, you're not going to give it to me. You're not going to refer me for an abortion, and I'm confused. I was entrapped in some way. So I think that there is an obligation to be clear about what an institution or individual is willing to do and not do, and why, and it has also the salutary effect of educating people about the moral principle itself.
If we were to have the preferred state, it would not be conscience clauses, it would be conscience legislation.
Yeah.
Because we are subject to the annual appropriations process, both at the state and the federal level, for these to be reaffirmed. So it's not been embraced as a stable piece of our polity. I was involved in the Hyde-Weldon discussions, which was just a messy time. And so because it's this, and Nita Lowy was going crazy with that one, who was very helpful to us on a lot of other things. But that's why what's being done here, no one has stepped back and said, what would be the substance of an affirmative piece of overarching legislation that would establish national policy? And then the appropriation cycle goes on, and the question is, does this piece of appropriation fit this national policy? Rather than trying to tack on to appropriations a protective statement. To use a bad choice of analogies, in a sense we're doing prophylactic activity rather than proactive activity of creating a stable moral framework.
I just wanted to say that the group of us and other people at the law school have formulated a proactive kind of general piece of model conscious legislation, and it's available on the website. You can get to it that way, and we're more than happy to discuss it. And we'll be hanging around all afternoon if people want to talk about any specific provisions, but not in this room because they're going to need it.
Why don't we go ahead and bring this part of the discussion to a close, but as I think you've heard from several people, the hope is that this is just part of a conversation that will continue and grow and spread outward. I think we all want to thank Father Jenkins for his initiative in helping to make this possible, and to thank all of my friends and colleagues at the law school for hosting this. You know, Father Place referred to the importance of the government allowing a space, a place, where distinct and coherent moral visions can be presented to the world, a world that's not always prepared to hear it. I hope we all agree in this room that Notre Dame can and should be precisely such a place. So thank you, and be sure you bring your boxes out with you when you leave.